I would like to cite an eminent scholar in the field. Quote, "Collective rights without individual ones end up in tyranny. Moreover, rights inflation, the tendency to define anything desirable as a right, ends up eroding the legitimacy of a defensible core of rights. The right to freedom of speech is not a lapidary bourgeois luxury, but the precondition for having any other rights at all," unquote. Those are the words of the leader of the Liberal Party of Canada, Michael Ignatieff, in his thoughtful book, Human Rights as Politics and Idolatry. I wholeheartedly agree with Mr. Ignatieff that freedom of speech is the bedrock right through which all others are secured, and I reject the Human Rights Commission's assault on it. Section 13 is deeply destructive. There are some 33 million people in Canada, yet, as Ezra pointed out, one individual citizen has his name on every Section 13 prosecution since 2002. I'm sure some of you are familiar with Matthew Hopkins, who in 1645 appointed himself England's witch-finder general and went around the country hunting down witches and turning them in for the price of £1 per witch. In 2002, Richard Warman appointed himself Canada's hate-finder general and went around the internet hunting down so-called haters and turning them in for lucrative tax-free sums amounting to many thousands of dollars. Hate-finder Warman and his enablers at the Commission abused the extremely narrow constitutional approval given to Section 13 by the Supreme Court in the Taylor decision, and instead turned it into a personal inquisition for him and his pals. Abolish Section 13, and life in Canada would be affected not one jot, except that Mr. Warman, Dean Stacey, and the other rogue civil servants would have to write their anti-Semitic, homophobic, racist website ravings on their own dime. Let me take the most recent example of a Section 13 conviction. The sole charge on which Mark Lemire was found guilty a month ago for a post that appeared at his website written by somebody else. That piece was read by a grand total of just 8 people in the whole of Canada, which works out to 0.8 of a Canadian per province, or if you include territories, 0.6153 of a Canadian. And almost all those 0.6153s of a Canadian going to this website and reading this piece were Richard Warman and his fellow dress-up Nazis at the Human Rights Commission salivating at the prospect of having found another witch to provide more bounty. In other words, no one in Canada saw this post. No one in Canada read it. Nothing could be less, quote, likely to expose anyone to hatred or contempt than an unread post at an unread website. Yet Canadian taxpayers paid for Jennifer Lynch and the Nazi fetishists at the Commission to investigate this unread bit of nothing for 6 years. And in the course of securing this itsy-bitsy single conviction, these psychologically disturbed employees of the Human Rights Commission wrote and distributed far more hate speech of their own. As Judge Lustig's and Judge Hadgis's recent rulings confirm, there is no justification for what Richard Warman and the CHRC did. And this is the sad truth about this disgusting agency at the beginning of the 21st century. There would be less hate speech in Canada, less hate speech, if taxpayers did not have to pay CHRC employees to go around writing it and publishing it. Sometimes institutions do things that are so atrocious they cannot be reformed. They can only have the relevant powers removed, as happened to the RCMP in intelligence matters, or be abolished outright, as happened to a Canadian regiment not so long ago. The Canadian Human Rights Commission should not be more insulated from accountability and responsibility for its actions than the Royal Canadian Mounted Police or the Canadian Forces. I call on this Parliament to assert its oversight role and to compel a full inquiry into the Commission, its investigators, their membership of Nazi websites, their conflicts of interest, their contamination of evidence, and their relationship with Richard Warman. Section 13's underlying philosophy is incompatible with a free society. Its effect is entirely irrelevant to the Queen's peace, and its use by agents of the Human Rights Commission has been corrupted and diseased beyond salvation. It is time for the people's representatives in the House of Commons to defend real human rights and end this grotesque spectacle. Thank you.
Thank you. We'll open the floor to questions. The first questioner will be Mr. Murphy. You've got 7 minutes.
Thank you, Mr. Chair. Thank you, witnesses. I'm going to give up my questioning in memory of Gordon Fairweather, who was a great New Brunswick parliamentarian and the first head of the Canadian Human Rights Commission. He held the seat. He was a Tory. I'm saying good things about a Conservative, so we're starting off very well. But I thought today we would have a debate really about the concerns about procedure, equality and fairness versus substantive law, and that is usually something everybody can agree on is egregious and should be an act that should be impugned. But I think you have raised mostly in your 20 minutes procedural matters, the far-reaching hand of the state, the inequality. Those are all very legitimate concerns, if proven. I will tell you that it's probably somebody's job to disprove some of the things, Mr. Levant, that you might say. I think particularly with respect to the allegation of hijacking a person's identity on page 38 of your book. I think if you said that about an individual, you'd be sued for libel, probably successfully. But that's not why we're here. I think we're here to discuss the broader issue of whether what is impugned is wrong, and whether, as Canadians, we believe what Justice Dixon said at the Supreme Court of Canada, when he decided that Section 13 is a valid constitutional part of our law. And then I guess what I'd like to ask you is whether you agree, at least, that the Canadian Criminal Code provisions are being appropriately administered, and whether there is, in fact, some curb on free speech. This is the fundamental question. Do you believe that there are curbs on free speech when free speech gets into the realm of hate speech, extreme speech, speech that is meant to, in the words of Justice Dixon, the late Justice Dixon, reduce people so that no one finds redeeming qualities in them? Hatred, emotions and feelings which involve extreme ill towards another person or group of persons. To say that one hates another means that there's no redeeming qualities in the latter. And the cases that the tribunals dealt with are issues about the Jewish lobby. The words spoken were that lied to us about Hitler. I'm not even going to go on because I don't think we need to hear the atrocious statements made. But they shock the conscience of people, and they go beyond freedom of speech. They're covered, in some cases, by the Criminal Code. So the question is, do you believe in the Criminal Code at least? And don't you think, the Criminal Code provisions on hate speech, don't you think there are limits? And finally, you know that the Criminal Code requires proof beyond a reasonable doubt, which is more difficult than on the balance of probabilities. You also know that the Criminal Code has punitive provisions involving jail, etc., whereas administrative tribunals, the sentences meted out are minor in terms of finances. So let's not truck with the administrative procedural aspects. Let's get to the heart of it. The question is simple. Are there limits on free speech in this country of Canada?
Of course there are limits to free speech. For example, the laws against fraud are a limit to free speech. The laws against forgery, laws about copyright. We accept these. All of these limits, uttering a death threat, has been in our criminal code for centuries. In all of these instances, though, speech is incidental. The substance of what is legislated is an actual crime, a harm, a violence. And what hate speech in our Human Rights Act does is it turns the ideas and the words themselves into a crime. And you say the punishments are light. I put it to you that a lifetime publication ban, $40,000 worth of penalties and fines, no legal aid, I put it to you that those are not light, especially for the people who are caught in that system. No legal aid allowed. But you outlined some of the differences between the Criminal Code and the Human Rights Act. The Criminal Code, if you're too poor to afford a lawyer, you will be given one. 90+% of people in the Human Rights Commission too poor to have a lawyer. In the Criminal Code, beyond a reasonable doubt. Not so in the Human Rights Commission. Criminal Code, truth is a defense. Not so in Human Rights Commission. Criminal Code, honest belief is a defense. Not so in the Human Rights Code. In the Criminal Code, we have procedural checks and balances. The police have to live up to an ethics code. There's an internal affairs organization. You can't entrap people. Not so in the Human Rights Commission. There